faith for a proper purpose, bona fide good faith for a proper purpose, avoiding conflicts of interest, not misusing position, not misusing information. Those provisions are about self-dealing. The second key area that we have to deal with is this issue of care and diligence. That's a fundamentally different conceptual idea going on here. It's about paying attention and bringing your faculties to bear on the problems that are facing the company. So let's dive into this second duty, due care and diligence. As I said before, while it's technically a fiduciary duty, that's largely an issue to do with history. In many ways, it's about not being negligent. You've got to concentrate on what's occurring. It's also the area that has developed the most over the past century. If you go back in history, right, a lot of times directors would get off not paying attention to what's going on. There are some famous cases, including, for instance, the Cardiff Savings Bank case, where the chair of the board did not attend. They attended, I think, one meeting in 12 years, right? One meeting. They turned up to one meeting in 12 years. Now, obviously, that's not giving care and diligence to the role. Right? But in that case, they said, well, you couldn't breach care and diligence because you never went to a meeting. That would not fly anymore. But I'm just giving you that as an example of the progression of this area of law. And it's a trend that we see continuing and growing. Greater expectations of a director's ability, their capacity to apply themselves to the tasks before them. So the main provision of acting with care and diligence is set out in Section 180. A director or other officer, so director or officer, must exercise powers that discharged with a degree of care and diligence that a reasonable person would. So it's not the level of care and diligence they thought they should. It's what a reasonable person should. So in that sense, it's an objective test. Okay, it's a reasonable person test, you'll remember, from your legal studies. So what would a reasonable person expect of a director or officer of a corporation in the corporation circumstances? Oh, okay. So it varies. Like, are you in crisis? Right? If your corporation is in crisis, wouldn't you expect a director to be using greater care and diligence? If you're an exceptionally large corporation with big impact in the world, wouldn't you expect a director to have greater care and diligence than if the company was, say, the local knitting association? Right? The company's circumstances matter as to the level of care and diligence you would expect. And so it's what a reasonable person would expect of a director in those company circumstances, and that the person occupied the office held by and had the same responsibilities within the corporation as the director and officer. Okay, so that means things like, are you chair of the board? If you're chair of the board, wouldn't you expect that person to exercise more care and diligence than someone who's not the chair? Wouldn't you expect more care and diligence of an executive director than a non-executive director? All of these things become important in terms of determining what level of care and diligence. And it's why even in the same case, there may be different levels of expectation of different individuals. And so some directors might get off compared to some other directors who don't because of these different expectations. Directors must act with the care and diligence that an objective, reasonable person would expect of that kind of company in those circumstances and someone holding that position. Look, the final thing I'll say about this Part B is this is some way that the courts have been able to get in a director's qualifications as part of the expectations of that director. In the Centro case, which we might go into more detail when we're talking about solvency. But in the Centro case, one of the things the judge pointed to was the letter of appointment of those directors. It said like the director, so just say I was appointed, it said that the letter said, Gavin Nicholson, congratulations for joining the board. You're appointed, we note with your appointment, we look forward to you using your financial acumen and skills. Okay, so because the letter of appointment said that, the judge said, well, that clearly shows that this office required financial skills. So now there is an expectation you will have care and diligence around financial issues, right? So you've got to look really at all of the materials that a board has, say its succession plan, a skills matrix, the letters of appointment. All of those things go into determining what the office held by a director actually involves. As I mentioned, while all directors actually face the same test of care and diligence, what we find is that there can be different levels of expectation because of this variation across the interpretation. Thus, the test is the same, but the standard varies. We'll find that the chair in particular will have a higher level of expectation as the position holds greater responsibility, they play a leadership role, and they have a pivotal role in the communication, which means you would expect greater care and diligence from that role. You could make the same arguments, for instance, around certain elements of what the board does, say the chair of the audit committee. You'd expect greater care and diligence around things like the finances from that specific individual, or even a member of the audit committee. You'd expect them to be more over the finances than a director who isn't a member of that committee. Now, the second element of Section 180 is the defence. This is something that students can find very confusing. I want to be really clear about this, right? The defence is not a breach of a duty or anything. It is a defence that you can make out. You can establish this defence, and it says you have exercised due care and diligence under Section 180, subsection 1. So it's not a separate duty or anything like that. It's a defence to the requirement to have due care and diligence. So what does that defence actually entail? There's a few technical things to understand about here. So the first thing is that the rule only applies to business judgments. If a decision is not a business judgment, then this defence won't apply. So for instance, if it was something to do with the appointment of directors, it's not a business judgment, so this defence wouldn't apply. But most of the major decisions that a board's going to be making are going to be business judgments. Okay, so if we've got a business judgment before us, we can't be doing anything dodgy in terms of our self-dealing, right? So there's a lot of talk here about our self-dealing requirements. Okay, so if you're conflicted about the issue, if you have a conflict of interest on the issue before you, you can't use the defence. Let's assume you don't. Let's assume you've done the right thing around that. Maybe you're only directors who are objective are taking part in the decision. The kicker in most circumstances, take away the self-dealing and the business judgment issue, the kicker for most people is going to be this one. A director must inform themselves about the subject matter. So you've got to ask, did you actually apply yourself enough? Were you informed? Or did you rely too much on others? Okay. And then there has to be some form of rational belief. There has to be some explanation as to why this decision actually made sense. Okay? But really, this is the kicker. You've got to inform yourself. And that is largely it, right? If you have informed yourself about the issue and you haven't been conflicted and you've thought about it, and you rationally believe that the course of action that you've decided is good for the company as a whole, well then, pretty sure you'll have undertaken your duties, both the fiduciary duty around self-dealing and also this due care and diligence. The final thing to think about are all these other duties that apply, and we've got a myriad of them here. The short answer is you're going to have to understand which legislation applies to you and what requirements come with that. Things like requirements under occupational health and safety will hit basically most directors, but there also may be areas, maybe you're a mining company and the Mines Act may apply to you with specific requirements underneath it, or the Telecommunications Act, right? So it's very hard to come up with it's, I think, impossible to realistically come up with a list of all the possible things that could apply to you as a director. That's why understanding what are the main pieces of legislation that actually apply to you and what are the requirements of you as a director are one of the first things you should do if you ever need to take on a directorial position. So as this slide sets out, there's a whole series of other requirements that are more specific about what we've dealt with. If you're listed, continuous disclosure requirements, related party transactions. There's about disclosure of director interest, which we talked a little bit about, conflict of interest. So there's often some quite technical extensions of these general rules that we've talked about. We've got insolvent trading under Section 588G, which we're going to do in Module 4 as well. So this is not the be-all and end-all, the two that we did, but they cover most of these situations conceptually. There's also a range of other legislation from a whole series of areas, whether it's broader society, workplace and industry requirements, or general business requirements that have requirements of directors that you need to understand. Now, all of this might get you a bit concerned. But that means I've got to do everything, right? No. Directors are quite able to delegate, provided you follow a couple of core principles. So let's think about what they are. Like, when are you responsible if someone you delegate to has done the wrong thing, right? When will you be held accountable under the legal requirements? Okay, well, first, sometimes the law says you can't delegate stuff. That's why you need to understand those specific acts that I talked about from the last slide. That's one of the problems that happened in the Centro case. The specific legislative provision said the directors need to sign the accounts. So they couldn't say, we relied on the audit committee, we relied on management, we relied on the auditors. Why? Because it said you had to do it. Okay, so you need to know the legislation. What are you specifically required to do? Now, if a specific piece of legislation doesn't require you to do the actual act in particular, then we can delegate. Section 198D, right, says you can delegate. When is it reasonable, right? Okay, reasonableness is set out into 190. You must reasonably believe that the delegate is going to act in accordance with the corporation, was reliable, and was competent. This means you really do need to do good HR, reference checks, appointment processes, right? Make sure the person you're appointing, you can justify your belief that they're reliable and that they're competent. If you can do that, well, we've got this part covered. The second thing you need to do is to make sure that there are no red flags to you. Okay, has the person done anything which makes you think that they might not be acting appropriately, right? Are they giving you honest accounts? Are they doing what they say they're going to do? Provided there's no red flags, provided you've done some good HR checks, and provided the specific legislation doesn't say you're not allowed to delegate, you can delegate and then rely upon it. Whew. Okay, so that gives us an idea about directors' duties at the individual level. The next series is going to look at the role of the group, the role of the board.